Bankruptcy accomplishes two objectives, the first being the protection of the creditors, providing the framework to allow the fair distribution of the debtor's assets between creditors' claims, essentially saying that one creditor does not take all the debtor's assets and leaves the other with nothing. The second would be, naturally, its protection of debtors, providing the opportunity to start anew and regain economic and self-sufficiency.
For individuals who have become overwhelmed by large amounts of debt, filing for bankruptcy is a potential solution. Filing for bankruptcy can allow someone with high debt to resolve the financial problems they face and possibly even start over with a clean slate. Before getting started, it should be noted that although bankruptcy may help you get rid of some or all of your debt, it will also stay on your credit report for up to 10 years. This means that you may not get a loan when you want one. Bankruptcy is a serious step, and how much it can help you depends on your situation. If you are thinking about bankruptcy, you should talk to a lawyer as early as possible. Bankruptcy may make it possible for you to get rid of the legal duty to pay some kinds of debt, including medical debt, utility bills, credit card debt, and other qualifying debt. Declaring bankruptcy can also temporarily stop certain actions by creditors, including foreclosure on your home, and if under Chapter 13, giving you a chance to catch up on missed payments, repossession of a car or other property, or force the creditor to return property even after it has been repossessed, wage garnishment, debt collection harassment, and similar creditor actions, or getting your utility service back or keeping it from being cut off. However, bankruptcy cannot fix every financial problem. Declaring bankruptcy will not stop you from going into debt in the future if your income is less than your expenses. Bankruptcy will also not get rid of debts that are singled out by the bankruptcy law for special treatment, such as child support, alimony, and most student loans.
Bankruptcy can be broken down into two categories, voluntary and involuntary. In voluntary bankruptcy, the person does not have to be insolvent or unable to pay their debts when they are due when they file their bankruptcy petition. In involuntary bankruptcy, any person or business owing $12,450 with the expectation of farmers unable to pay their debts when they are due are forced into involuntary bankruptcy. If more than 12 creditors have unsecured claims to that debt, at least 3 must sign the petition. Informations to be filled with courts with the petitions include a list of creditors and amount owed to each, a list of property owned, a statement explaining financial affairs, a list of current incomes and expenses, and finally, after the petition is filled, a trustee is selected to protect the debtor's assets and liquidate them, paying back the claims to the estate with proceeds. Debts that cannot be discharged due to bankruptcy include certain taxes, alimony and child support, claims against debtor for property obtained by fraud, embezzlement, or larceny, judgments against debtor for willful and malicious injury, student loans unless due 7 years before bankruptcy, and claims unlisted by debtor. Exempt properties include real property, also known as homestead, life insurance payments for a person depended on for support, life insurance policy loan value, alimony and child supports, pensions and retirement benefits, $525 per item of household goods, animals, crops, clothing, appliances, furnishings, books, and musical instruments up to $10,775. It also includes health aids, jewelry up to $1,350, motor vehicles up to $3,225, personal injury compensation payments, wrongful death payments, crime victims compensation, public assistance, Social Security, unemployment compensation, veterans benefits, tools of a debtor's trades, books and equipment up to $2,025, and $1,075 of any property plus $10,125 of unused homestead exemption. Creditors need to be able to protect themselves from debtors who may not be reliable. There are several legal ways that creditors can do this. Pledges. A pledge is when a debtor gives up possession of property to a creditor in return for a loan. When a loan or interest is paid back to the creditor, the debtor is given back his property. A pawn is a type of pledge. Usually, it involves something that is small and valuable. Creditors who deal with pledges, like pawnshops, must abide by several laws. They must be legally licensed, they must keep interest rates under a certain limit, and they must wait a certain amount of time by selling pawned goods, usually months. Liens give people who owe payments for services the right to seize property if they are not paid. Usually liens are agreed upon in a contract, but some are mandated by law. Mechanic's lien. It is when a mechanic who has not paid for a building or repairing a house. This property may be sold, and whatever debt the mechanic has owed will be paid to him out of the revenue from the sale. An artisan's lien allows people who have not been paid for services on a possession to retain the item until the money is paid. Example, if I got an IT specialist to repair my broken iPhone, but then refused to pay him, he can keep my iPhone until I have paid him for the services. A mortgage is a sum of money lended to a person in order to pay for real estate. The lender forces the signing of a letter by the borrower that gives an interest rate on the property as collateral. Failure to comply with the mortgage usually results in default, where the mortgage would forcibly sell the property to satisfy the debt. A surety is a third party who agrees to be held liable in case of a default by the principal debtor. He is basically there in order to make sure the debt is paid. He is just as liable in the agreement as the primary debtor is. A guarantor would also be in the same place, except, unlike the surety, he is secondarily liable. So that means the primary debtor is always held responsible in this case and puts less stress on the third party than the surety. Unsecured debt pertains to a small amount of money that is lended to someone in an oral or written agreement. This is much riskier for the creditor because he is putting a lot of trust in the debtor to pay him back. If the debtor does not pay him back, the only way to get the money is to sue, which is expensive and time-consuming. Garnishment of wages. Garnishment of wages is when a creditor receives a portion of the debtor's paycheck. This process is usually limited to only 25% of a person's wage, and that is the only percent that can be garnished at a time.